In this video, I'm going to walk you through the criminal court process in Indiana from arrest to trial. We're going to talk about each step so you know what to expect if you're going through a criminal case here. So about me, my name's Nathan Vining. I'm a criminal attorney here in Indiana, and hopefully by the end of this video, you're prepared to know a little bit more about what you can do in your case. So really, the first step in an Indiana criminal case is the arrest. It's important to look at your arrest closely because the police have to have probable cause to arrest you, which means they have to believe that there is some criminal activity occurring. Ultimately, you have a lot of rights, such as the right to be free from search or seizure, the right to not make statements, the right to have evidence collected through the proper procedures. So understanding the arrest process is crucial for protecting your rights. So you're going to want to talk to an attorney if you've been arrested to see if the right process has been followed through each step of the arrest. After you've been arrested, the first hearing is what's known as an initial hearing. In other jurisdictions, they may call it an arraignment, but typically it has to occur within 48 hours after your arrest. Here, the judge will formally inform you of what the charges are, where they will read you what has officially been charged, what crimes they are alleging have been committed. Here, the judge will enter a plea of not guilty on your behalf. You do have a right to counsel, so it's at this hearing where the court may determine whether or not you qualify for a public defender and appoint one if you are. And then here, you would want to consider your options and talk to an attorney prior to going into an initial hearing. Ultimately, depending on the case and the level of charges, this is the type of hearing that may be able to be waived. So a lot of times, if I'm practicing in Indianapolis and you may have picked up charges and you're from out of state or from out of town, you can waive this hearing and actually have to avoid traveling some distance to get there. So it's important to talk to an attorney, understand your options, as well as prepare for the initial hearing because, for instance, if there's an OWI, your license may be suspended at this first hearing. You may have additional arrest restrictions put in place. An attorney can help address driving privileges during the duration of your case as well as pretrial restrictions. So get help if you're looking at this kind of hearing. After the arrest, at this point you may or may not still be in custody. So it's also important to consider bail. If you have a loved one that is in custody, an attorney can file a motion to reduce bond. This is the kind of thing where the judge would assess your criminal history, your flight risk, your connections to the community, and determine whether or not the bail is set is appropriate. It's important to know that this is a kind of a double-edged sword because the court judge could look at those things and determine you are a flight risk and actually increase bail. So you're going to want to get good advice there to determine whether or not bail is appropriately set according to the county standards. So ultimately, bail is an important consideration at the start of a criminal case. After you have been through the initial hearing and either bonded out or maybe you're actually in custody and your loved one's awaiting trial while in custody, the next real step in a criminal case is discovery. Typically within the first 1 to 2 months of a case, the state's going to turn over what evidence they have against you. This can be things such as body cams, videos, statements, detective notes, all sorts of stuff, the physical evidence in the case, or at least pictures of it. So you're going to want to see the evidence and make sure that any attorney you have turns this over so you can review exactly what the state has against you here. So discovery is kind of the third big piece of a criminal case. There's also several pretrial motions that may occur in your case. Maybe there's issues with venue, maybe there's evidence issues. For instance, maybe there was something that was obtained without a warrant and you believe that it should be excluded from evidence through a motion to suppress. If you have a family member in custody, you can file a speedy trial request, which ultimately means they have to bring a speedy trial. There's also certain defenses that may need to be filed. A lot of times you don't have to provide notice of a defense, but there are specific defenses where you have to provide notice, such as self-defense. If you're going to allege that maybe there was a battery and you acted in self-defense, you're going to want to put the state on notice of that. Another big one is notice of alibi. Maybe you're alleged of something and you were actually in a different location at the time and have evidence that you were in a different location. You would need to put the state on notice of your alibi defense. So you're going to want to talk to an attorney to make sure that you don't miss any important deadlines with pretrial motions. A big part of a criminal case here in Indiana are pretrial conferences. Typically, you would have that initial hearing, then the judge would set the case for a pretrial conference. A lot of people may not know what this kind of hearing is, but they happen in nearly every criminal case in Indiana. And ultimately, How it happens, it occurs differently in different counties. Some judges may have you go on the record and have a formal hearing where the judge hears a status from the parties as to where the case is going and what they need the court to do at different points in the case. Other counties, you actually may go meet with the prosecutor in a jury room and discuss the case and file a motion or a notice with the court as to what happened that day. But ultimately, the pretrial conference is a chance for the prosecutor, you or your attorney, as well as the judge, to discuss the case and the status thereof. So a lot of times at the first pretrial, it would include reporting to court if there's any discovery issues or if discovery's been tendered. It would be reporting to court the status of plea negotiations, as well as working on pretrial issues. You may need to set suppression hearings or other hearings at the pretrial conferences. And then also, ultimately, you may set trial dates or other dates at these hearings. So that's what a pretrial conference is. Next, you may work on plea negotiations. Most criminal cases actually do resolve in plea agreements. And what a plea agreement is it's an agreement between you and the state that ultimately, if the judge accepts, it would resolve the case. And a lot of times you may be charged with, say, a level 3 felony. You could work it out. So maybe you're pleading to a lesser included offense and pleading to a level 6 or level 5 felony. And then it also would include terms. A lot of times you may be able to negotiate a plea for probation, for non-reporting probation, or maybe you're facing a major felony when you work out a plea for home detention. So ultimately the benefit of the plea is that it reduces your jail risk. So plea agreements are a big part of a criminal case. It's important to have an attorney that understands the nuances of plea negotiations so you can work to see if you're able to obtain a favorable outcome through plea negotiations. There's also things known as pretrial diversions, and potentially if you have little or no criminal history, you may qualify. And ultimately that's similar to a plea agreement, only it's an agreement between you and the state where they will withhold prosecution. So if you stay out of trouble for 6 to 12 months, satisfy certain requirements, the state may actually dismiss your case. And ultimately, though, if you do not resolve the case through a plea agreement or a pretrial diversion, you can actually pursue trial, and that can be done one of two ways, either through a trial through the judge or a jury trial. It's important to know that in a misdemeanor case, it's automatically set as a bench trial with the judge, and that you would need to request a jury trial at least 10 days before your trial setting. But ultimately, the trial is where you would present opening statements. The state would present their evidence that they believe against you. You would have the right to cross-examine all of their witnesses and as well as present a case on your behalf. And then ultimately the judge or the jury would issue a verdict, either guilty or not guilty. So ultimately the kind of the three main ways you would see a case resolved would be through a trial where there's a verdict, through a plea agreement where there's an agreement as to what the sentence would be, pretrial diversion, and then the last, sometimes maybe you cannot reach an agreement with the state, but the risk of trial is too great. You actually could plead open to the charges and work with your attorney to put a mitigation packet together to explain to the court, yes, maybe I am guilty, but here is why you should give a more lenient sentence here. So there's a lot of strategy in a criminal case, whether it be plea negotiations, trial strategy, or even just sentencing strategy. And then the last part of a criminal case in Indiana is sentencing. And this would happen either if you get a guilty verdict at trial, plead open, or enter a plea agreement. Ultimately, the court, they're not a party to plea agreements, so they would need to hear evidence to understand should they accept or reject a plea agreement. And a lot of times in a sentencing hearing, this is where oftentimes it may be the defendant's first chance to speak. You have a right to remain silent. So at trial, you may have not said a word, or maybe you took the stand. But you would have the right to give a statement of allocution and explain what occurred that day, as well as argue what you believe an appropriate sentence would be. A lot of times, if there's a plea agreement, the sentence would be set out. Other times, there may be what's known as an open sentence, and you would get the chance to argue to court as to what the sentence should be, whether that's home detention, probation, or even a suspended sentence. So there's a lot of factors here, but ultimately the goal would be to explain why the court should accept the sentence you're arguing for, as well as present any kind of mitigation evidence, whether that be positive things you've done since the arrest to change your life around. So if you have questions about an Indiana criminal court case, feel free to give me a call or text me. I'd be happy to review a situation with you and make proposals or recommendations about what we would do in your situation.